global uncertainty surrounding the licensing of standard essential patents, or SEPs, looks set to persist in 2023. SEPs must be licensed on fair, reasonable, and non-discriminatory terms, or FRAND terms, and the uncertainty stems from the fact that there is no formal definition of FRAND terms. In the past, FRAND terms have been determined by courts on a case-by-case basis. The need for clarity is only growing. Litigation over SEP issues is ramping up, especially between patent owners and technology implementers using advanced wireless technologies, such as 5G and Wi-Fi 6. In 2022, we saw some new policies from the US and other countries that attempted to balance the interests of patent owners and licensees. But the US still does not have an official policy on the appropriate remedies in an SEP FRAND dispute. Without that guidance, litigating parties in the US face substantial uncertainty. In June 2022, the DOJ and the National Institute of Standards and Technology announced their withdrawal from the 2019 policy statement on remedies for SEPs subject to voluntary FRAND commitments and pledged to review conduct by patent holders and implementers on a case-by-case basis. But it remains to be seen what that might actually look like in reality. Other jurisdictions have taken a more aggressive approach. For example, China's highest court ruled that it could set the terms of a global FRAND rate if the dispute has an appropriate connection with China. A UK court found it had jurisdiction to hear global disputes because the patent owner's FRAND obligation stems from a contractual commitment made to standard-setting organizations, or SSOs, and because the national courts may adjudicate disputes relating to those obligations. We may at least see some clarification in the EU in 2023. The EU is currently assessing a new framework for SEP regulation with a focus on transparency and efficiency in minimizing licensing disputes. While Europe is certainly one of the most popular venues for SEP disputes, South America might become a more popular venue. Ericsson recently won a preliminary injunction against Apple in Colombia, and patent holders might try to use similar injunctions to accelerate licensing negotiations. On the litigation front, a recent ruling from the Fifth Circuit resolved the Continental Automotive Systems versus Avanci case, finding that Continental did not have Article 3 standing to bring an antitrust lawsuit against Avanci after Avanci refused to license Continental. The decision confirms that patent owners have significant discretion in developing their licensing programs. SEPs are thus likely to continue licensing the end manufacturer of products, since those agreements likely offer the highest license payments. Check out additional videos in our 2023 IP Outlook on our website. We're examining top trends and decisions in IP law from the past year and sharing what you and your business should look out for in 2023.